Good evening to the participants of the JCJ 2022 main examination. And today topic is the continuation of the last class topic, that is the kinds of the mole property which cannot be transferred. So that is the thing which I want to make it out. So I'm sure that you could see my screen. Say yes.
Yes, sir.
Good, very good. So in my yesterday class, we are up to this extent. And here, the owner of the house, was right of way over there, adjoining land with N. Hence, M cannot transfer his right without transferring the house. This we made an explanation like weaned cow and unweaned cow that we discussed. Is it or not?
Yes, sir.
And something you asked that meanwhile that time is up. What is the thing that you asked?
Yes, sir. I asked whether what is the meaning of weaned and unweaned, sir.
That I
Later, I
give the
came to know.
answer.
Yes, sir. I came to know.
But I already told you that one thing also there. A woman feeding through the breast. Am I right?
Yes. Yes, sir.
What about the animal?
I have written somewhere, sir.
Okay. It's called udder. A-U-D-D-E-R. Udder. And animals having four teats. T-E-A-T-S. Teats, we will say. Is it clear?
Yes, sir.
Okay, now let us go to the next. Section 6D. Restricted interest. A person cannot transfer anything that is interest restricted in the enjoyment to him. Restricted rights are personal and cannot be transferred. If such transfer happens, then it would be a void. The following types of interest are not considered transferable, such are the first small bullet, service tenure. It cannot be transferred. And second bullet is a right of preemption. And third bullet is emoluments. And the fourth is religious office. These are the, it cannot be transferred because it is only restricted to a particular person. Example which he has given here is the right of a priest to receive the offering. This right is his restricted interest, and he cannot transfer his right to another person who may be a doctor by profession. You know that who are the person, those who make Mangala Harati in the temple?
Pujari, sir.
Not Purohit.
Pasan, sir.
Okay. Because certain temples, only that clan could be a pujari, no other person. Father, 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 means father, son, son, son. Only that clan will be the pujari, no other person.
Hereditarily, they'll come, sir.
Yes, yes. And especially because one case law also there. Because they say whatever the temple property would be there, that is restricted only to the that family, clan family, not to anyone. And if they want, they can give for the rent. If they want, they can give for the harvesting. But that property, I believe it cannot be sold. So here, service tenure, a priest service tenure is there, a purohit, and that cannot be transferred. A right of preemption. I don't know whether you know preemption or not. If you know it, you tell me. If you don't know it, you say pass on.
When there is co-partners are there, sir, that means shareholders. If one shareholder want to sell his property, then the right is given to other co-sharer, sir. First preference must be given to co-sharer only, not to a third person, sir. That is right of preemption.
Not the new person.
Yes,
If
sir.
the property belongs to all the co-partners or brothers and sisters, if the brother wants to sell it, first ask the adjacent portion belongs to another brother, then whether you would like to buy it. And if you say no, then he can go for the other people. That is called right of preemption. Actually, preemption. So that cannot be transferred. Emoluments, these emoluments also personal in nature. Then it cannot be transferred. Religious office, like I told you, Prohit.
Emolument, sir, means what is?
Emoluments means here for like perks, like car fuel allowances, peon allowances, and even a house girl who works in the house, domestic servant, and the quarters. So these are the extra benefits which are given, and they will consider as a other perks or emoluments. And these emoluments cannot be transferred. It is personal in nature, depending upon the status of a officer. Is it clear?
Mama.
Shall I proceed?
Yes.
So
Yes, sir.
example here is right the priest. Yes, the priest receive the offerings. No, it belongs to him. He cannot transfer it. Of course, he wants to give it. He can give to somebody else. The right is his restricted interest, and it cannot be transferred to his another person who may be a doctor or a profession, because only clan people will be the priest and purohit. The next section 6, clause double D, right to future maintenance. This clause states that the right to future maintenance whatsoever cannot be transferred in any manner. This is because the right is solely a personal benefit given to a person, and so he cannot transfer his benefit to someone else. Like maintenance. Does it will be transferred maintenance?
No, sir.
Maintenance of your wife. Maintenance to your
No,
wife.
it
It will,
can't be transferred, sir.
it will be personal in nature. See, after my death, let it go to my somebody else. After death, there is no question of maintenance. Am I right?
Yes, sir.
Even after the second marriage, whether she is
And
entitled for the maintenance.
yes, sir.
So he can marry to a rich lady
She must
fellow. Again, she claims the maintenance from the former husband.
go for second marriage. She loses herself, sir.
Either death or second
She
marriage.
remains.
That was the condition.
Yes, sir.
Shall I proceed?
Sir.
A woman who receives the maintenance from her husband under a decree or award or order, in the case of the Dhupnath Upadhyaya versus Ramacharit, it was held that where the property is given as a maintenance, then the person cannot transfer the property during her lifetime. A right of maintenance is a personal right and cannot be taken away. So, such a maintenance cannot be transferred over there because it is a personal in nature. So, section 6, clause E, right to sue. According to this clause, a mere right to sue cannot be transferred. A right to sue cannot be transferred as for the transferee acquires no interest in the subject matter of the suit as much as the owner of the property would. See, if a person wants to sue it and he cannot transfer to somebody else, you can sue on behalf of me because I don't have money. Can he sue the third person? Only the public interest litigation where a person could make it out, even though he is not a victim.
Party.
So, example, X published a defamatory statement against Y, and Y filed a suit against X, but Y cannot transfer his right to Z to recover damages for him. And if he transfer his right to Z, then his transfer will be held void. Who was defamed in this example?
Why, sir?
Y. Then who is having the right to sue X?
Why he has right to sue?
Can he transfer his right to his son?
No, sir. It's his personal right.
It is a defamation is a personal in nature. Once died, over. What is the maxim in the law of tort? Actio personalis maricum persona.
Monitor. No. Yes, sir.
The personal action is with the
Person.
person. But there are exceptions are there. And we do have a very famous case law. Klaus Mitterbachert case law. That is a German pilot case law. I don't know whether you remember it or not. Sir, we studied very long back. No, sir. That's why we could not remember that thing. Klaus Mitterbachert. That is a German pilot case law. And where once he died over there, already he got the much more PF and other activity, medical expenses from the hotel chain. That is hotels of the Continental Hotel or some hotel chain is there. So they applied this maxim. But in single bench, they won it. But in the appeal, of course, they lost it. But by the time, the victim got a lot of damages. So, Section 6F, Clause F, public office. A public office cannot be transferred. And so the salary of the public officer, whether before or after it becomes payable. If a public officer is a person who is appointed to discharge his duty towards the public, and for doing such an act, he is paid in the form of salary. This salary is a personal benefit to him and can't be transferred. What is the difference in salary and honorarium? If you know it,
Salary
yep.
for monthly payments, sir, for his particular performance or activity. Honorarium means particular act only, sir. I think.
There is no fixed amount.
In
They may give a
honorarium.
token of amount as an honorarium. But salaries,
Fixed
Which is
and
fixed.
it will be
it depends upon the basic scale and HRA and rest of the other thing. There is a equation. Are you following me? Say
Yes,
Yes,
sir.
sir.
Good. Section 6, Clause G, pensions. Generally, pensions are the monetary value like a salary given to a person timely who ceases to be a government employee. This pension is benefit which cannot transfer just like his salary. Of course, in one respect, pension will be transferred. Can you tell me in what situation?
Pass on, sir.
Yeah, say pass on if you don't know, don't waste the time. Suppose the
Maintenance, sir.
husband is a government employee.
For maintenance.
What maintenance?
If somebody is a government employee,
If the husband is a government employee, if the husband dies, his pension half would be transferred to the surviving wife, valid wife. Yeah, right?
Sir, the remaining half, sir, what they will do?
No, it will be go to the estate.
Okay, the government will take.
Only half would be given to the widow.
Okay.
Suppose that fellow is having the 4 widows, which is impossible nowadays. Then it will be 1/4.
Okay.
So,
That half will be divided to.
suppose the wife dies. The widow dies. Say, pass on.
Children will get, sir.
A widow child or a child who is dependent and like mentally retarded, he could not marry, dependent upon the widow, and such people will get the pension. But how much, I cannot say whether the same amount which the widow is getting or lesser than that, but it can be transferred. Shall I proceed?
Yes, sir.
So the pension in that only circumstances can be transferred. Otherwise, pension with the personal only. So here, Soundarya Boy versus Union of India, it was held by the court that pension is not transferable as long as such is in the hands of the government. Yes, now section 6H, nature of interest. According to this section, the transfer should not affect the nature of the interest of anyone. For example, the public or religious uses or services cannot be transferred. If any transfer whose object is unlawful, has unlawful consideration, is not permissible under this section. Also, if the property is transferred to someone who is disqualified legally to be transferee, then such a transfer is not valid. So, what is the nature of interest for the transfer also will be taken. Suppose if you transfer it to a particular person who is a transferee, who is not qualified to be a transferee at the time the transfer is valid, invalid, means not valid. Example, read the example. Participant, read the example. Krishna Yadav,
Yes,
unmute
sir.
and read.
Yes, sir. I can view.
Yes, please.
X, Y, and Z entered into an agreement for the division of gains among them, which they acquired by fraud. Hence, this agreement is void, as the consideration is unlawful.
Yes, it
What
is,
does not constitute
yes, enough.
transfer?
It is very much self-explanatory. X and Z entered into an agreement. For what? Division of a gain among them which are acquired by fraud. They got some amount by fraud and they want to share equally. Such agreement is not valid because the gain which they got is by fraud. Is it clear?
Yes, sir.
Suppose there is a bank robbery and there are 4 or 5 members, 5 members are there. After robbing, they made an agreement. Everyone should be have the same share. Even the person who entered, even the person who is standing at the gate also. Later on, they did not agree to that one because I entered inside and I opened the strong. What is that? Strong?
Locker.
No, there is something, a specific name is strong room or strong almirah, a locker, and where the money would be kept it over there. Strong, generally we'll say strong room. So from there he came over there. I am the person who actually did it. Such agreement is void because there is no such unlawful act, there would be an agreement. Am I right?
Yes.
Good. What does not constitute a transfer? Now let us see. Property of any kind can be transferred. Exception to this rule is the general rule of the Transfer Property Act is that any property can be transferred whether movable or immovable. Okay, generally. Can you tell me what are the modes of transfer? Quick.
So land.
I say mode of transfer.
Sale, gift, mortgage, lease, etc. Sir.
Exchange.
Exchange also, sir.
Even actionable claims also will be transferred. Even will, but will not come under the transfer property.
Yes, sir.
section
Will and
six.
party.
Yeah, it's a separate would be there. Succession will come into the will. Am I right?
Yes, sir. Yes, sir.
Indian Succession Act. Yes, Section 6 states that property of any kind can be transferred except otherwise provided by this act or by any other act for the time being in force. It lays down the exception as number 1 exception. Salma, unmute and read. Exception 1.
The chance of heir apparent succeeding to an estate. The chance of a relation of obtaining a legacy on the death of a kinsman or any other meet possibility of a like nature cannot be transferred.
Okay, enough. The chance of heir apparent. What is the word we used it in the legal terminology?
Legal.
Just yesterday. Of course, day before yesterday.
Possessionist.
Spes successionist. His apparent. Okay, I am the only the legal heir of my father.
Yes.
And I know that I am going to get it when the father is kicked the bucket. What is this kicked the bucket?
Passed away.
That is a phraseology. So passed away. At that time, we cannot transfer it. The reason is Even to get the property, he may kill. Am I right?
Yes, sir.
Yeah, that is the way
So-
stress section is. Mere apparent succeeding, it cannot be transferred. The chance of relation of obtaining legacy on the death of the kinsman. Here, legacy means, what is meant by legacy? Either in the form of a will, mostly legacy in the form of a will. Am I right? The legal
Yes,
heads
sir.
will get it. Of course, if there knows will, naturally it will be, Indian Succession Act will come into the picture. If the will is there, again, there is some formula is there. Can he give in the will the entire property to the only elder son?
No, sir.
Other people will challenge it on that one, because they say the younger brother, the elder brother manipulated my father and forcefully took the signature of him. Hence, we do have some doubt. How could he make the will of only elder son, even though we are also valid and same blood, same mother, and same father?
Yes, sir. So one case is there, the same thing, the same
Sir,
scenario.
please tell me.
There are 4 sons,
Okay,
and the father expired, and
okay,
the mother, she's staying with the third son.
uh-huh,
Okay. The third son took her mother, and he is taking care of her mother.
uh-huh,
And where the father, what he has done is, before he expired, the whole property he has done on his wife, that is mother.
okay,
So the third son, cunningly, what he did, he took the mother, and he was taking care of her mother completely.
okay,
So now she is very old, around 90 plus,
okay,
and he's like he's trying to take that property,
yes,
because
yes,
he's seeing from very long time,
okay,
and he's saying that this property comes to me only,
mhm,
as he's taking care of his mother from very long time.
okay,
So the other 3 brothers, what they have done is, like they have approached the court.
okay.
So the same case is running right now with my
See,
senior.
no doubt. Okay, let me say that he is the only third son taking care of the mother. Okay, we do admit it. Let him may take
Yes.
some more portion more.
Yes,
And
the same thing.
because mother also entitled,
Yes,
so let the mother will give the property to the third son, whatever the share would be there, because it is he
yes,
who is taking care of it.
yes. Mother, she's saying that she's saying that, as you said, you can take a bit more person, like 30%, and you can
Yes.
give the remaining share to other person. But this guy is not listening. He's saying
Okay,
saying that
that
I
doesn't
want.
matter. Whatever the portion comes to the mother, and whatever the
Yes,
portion comes to the brothers, let them take it. Later on, this mother will write to the third son.
yes.
Yeah, that can
That's
also be
yes.
possible. But
Yes, yes.
but if the elder son is a IS officer, the second one is a pilot, and third one is only a clerk, and the fourth
Uh,
one is, say again, we will say he's a custom officer. At that instance, as per my opinion, I give entire property to my third brother,
okay.
not
Because
expecting
the other
any
persons are
single
well
pay
settled.
from, not expecting single pay from them, because we are well to do, and that fellow will
Yes,
is only the clerk. Let them enjoy it,
mm,
what is there,
yes, yes.
and will
But
sign. All of the three will sign on the document. We
yeah,
Our share we are giving to my third brother, and of course, mother will she will be entitled it, and she will get her own share. So that is the way. Can the court will make objection?
if they are mutually
They
they go ahead
voluntarily
with that.
giving.
Yes, voluntarily, the court will accept that.
The court will
Yes, sir.
not interfere in that matter.
Yes, yes.
Okay, that is the explanation. The second point is a mere right of re-entry for any breach of a condition and cannot be transferred to anyone except the owner of the property who is thereby affected. Suppose if you have given the lease a land and you are the owner of the property, if the lease period is over, you can enter into the property of yours because the lease period is
Over.
Over.
over. Sir, over is right word or exhausted is right word? Which one is the right word?
Over is right words.
Generally, we don't say exhausted because the things which will be countable can be exhausted, like food is exhausted, or something like that exhausted, we can say, but other things we don't say exhausted, as far my
Energy
knowledge
they
goes. Am I right?
Yes, sir.
So when you speak like a Professor Hussain students. That's my intention. Okay, third point is an easement cannot be transferred apart from the dominant heritage. We already discussed. If I have the right of way, so I am the dominant heritage. And the person on whose land I am walking, and he is having the servant heritage. Am I right?
Yes, sir.
Yes. Then the fourth point is all the interest in property restricted in its employment to the owner personally cannot be transferred. It is attached to the person, it cannot be transferred. Because even a right to future maintenance in whatever manner arising, secured or determined, cannot be transferred. And we will say, who will see tomorrow? कल किस कल किसने देखा? In either Urdu or in Hindi. Am I right?
Yes, sir.
Kal means tomorrow. Kisne dekha means no one has seen it tomorrow. Suppose if you are alive only, you could see tomorrow. Am I right?
Yes, sir.
So
Inshallah.
future property cannot be made such a thing. Even a person also cannot be transferred. The fifth point is a mere right to sue cannot be transferred. Like the example which I have given, X defamed Y, and Y can sue the X. Suppose X is died, sorry, Y is died, who was defamed, he cannot transfer to his son. But if it is a debt property, yes, it's a debt, DEBT debt, అప్పు. మా నాయన అప్పు చేసిండు, మా నాయన అడుక్కోపో. Can you make it so?
If the
No,
person
sir.
who took the money, if he has all the documents like everything proof, then they can borrow from the son.
When you enjoy the property of your father in the form of succession, whatever the debt should be there, you should clear it. Am I
Yes,
right?
sir. Yes, sir.
Yes.
Then only the rest of the property go to the legacies. Means will. That is called legacies. Okay, number 6. A public officer cannot be transferred, nor his salary, whether before or after becoming a payable. Just we discussed earlier, the repetition here. And the 7th thing is the stipend allowed to the military officers, or naval officers, or Air Force, or government, or political pensioners cannot be transferred. Yes, because it is personal in nature. Am I right? But we
Yes,
depend
sir.
in pensions of the father, government employee. Okay, after death, the widow would get it. After the death of widow, if any widow would be there, or dependent would be there, they are going to get it. But as for the 50% to the widow, but I don't know exactly whether the 50% same would be given to the dependents or not. That is doubtful to me. But there is a provision is there. So 8th one is no transfer can be made insofar as it is opposed to the nature of the interest thereby affected or for the unlawful object and consideration under section 23 of the Indian Contract Act. It is an unlawful agreement, cannot be made it. The example which you made it, they sabotaged, they robbed the bank, and whatever the amount will be there, they want to equally share it. Later on, was a disagreement. The agreement cannot be a valid agreement because the purpose they obtained is in wrongful way. Is it clear? Okay, now decided cases we will see. Sheshambal versus Hassan Kahani Rautar. In this case, it was held that an heir who received an advantage for giving up his future right to property, then heir could not be allowed to benefit of the doctrine of specific succession. Apparent succession cannot be transferred. Who is going to get later after the death of the father? Next case lies C. Mohammed versus Anantachari. In this case, the court held that there can't be an easement by prescription if the person admits that the property belongs to him. See, once you admitted it, the property belongs to you, where is the question of prescription? The court defined the easement as where an owner of the property has the right over the way of the labs for the another purposes, which is connected with the beneficial use of his own land. And here the point very much clear is there. If you sold the property, it can be transferred. But you assign the property, you cannot be transferred to others. So that is only the thing we should have to remember it. Anantaya versus Subbarao. In this case, it was held that if there is an agreement between the two persons who are brothers by relation, and one of them is agreed to pay a certain amount of money from his income to his brother for his expenses, as he takes care of him, and then in the cases, the provision of the public officer would not apply. See, if I give an example like that, if the last brother will take care of the mother, and for that regard with the agreement between the elder brother to give some money to the younger brother because he's an employee, but he's taking care of the mother, if such an agreement would be there, then definitely from the public officer, it can be passed to the mother. Like the bank will come forward to the government employees, including the pensioner. Sir, మీరు కార్ కావాలనా? Because they know that we are the government employee and we are getting the pension. Now they are getting the pension more than what they are getting at the time of their job.
Working.
See, the
Yes,
job
sir.
I came to know, one of my relatives say, I used to get only 20,000, something like that, after deductions. And that to be at the end of their last salary. But now the same person is getting 70 to 80,000. Of course, income tax is there. But to
Yes.
me, how you tax the income, that pension, that's my point. How could people will tax the pension? No, that is also amount, no. Better it would be. Or when the people are getting the millions together, there is no tax for them. And these people, those who are white money, on that there is a tax. And somebody challenged, could you tax on gratuity? Yes, anyone? Participants.
I think no, sir. They won't.
In some country, they challenged it, but they said, no, gratuity should not be taxed.
Yes, sir.
It is giving out of compassion or out of when the job is over, gratuity will be paid. Either 15%, 25% to your either basic salary or the gross salary. Of course, depends upon the terms and conditions. If the gross salary would be there, the amount will be bigger. They never give to the gross salary. They will give to the basic salary. Am I right?
Yes, sir.
Sir, we are not the government employees, sir. That's why you don't know. Not necessarily one should have the government employee to know these things. Okay. Setupati versus Chidambaram. In this case, the court held that in the right to sue, the word merely means that the transferee has no interest in the subject matter than just a bare right to sue. See, again the suing comes. It is the interest is there. If they want to sue, he can sue it. Suppose if a person doesn't want to sue, could the government force him to sue? Could the court force him to sue? Answer.
No, sir.
No.
Because he wants to waive the right. And another case, La Palani Gaudhan versus Nallappa Gaudhan, Goundhan. In this case, the court held that if an ex-minor transfers his property without the authority of his guardian who has sold the property during his minority, then the transfers his interest on the property, not mere right to sue. What did you understood by this case law? Read. Anyone can read and explain. Participants. Sir, we are reading in our mind only, sir. Later we will come to the point. Of course, if we read loudly, we could not understand, sir. The court held that if an ex-minor transfer his property without the authority of his guardian, who has sold the property during his minority, then he transfers his interest on the property, not mere a right to sue. The question over here is, if the property is without the consent of guardian, if you transfer, the transfer is invalid. Am I right?
Yes, sir.
When there is a guardian is appointed. And
Yes.
and regarding the suing is concerned, when it becomes emancipation of it, after that one, a guardian cannot sue. Am I right? Because
Yes,
he gave me a major. When he became a major, the guardian can sue.
No, he cannot sue.
He cannot sue. If he wants, the major person who has sued it, he can make it out. Otherwise, he cannot make it out. So not merely a right to sue when he becomes a major, that would be the idea behind it. The Bharat Petroleum Corporation versus P. Keshavan, in this case, a deed of lease was executed about 22/11/1967 by one Srimati Angammal, wife of Sri Angappa Chettiar, in favor of the Burma Shell Oil Storage and Distributing Company Limited. The Burma Shell is turned into the, now what? Burma Shell turned into now what? Sir, we don't know.
Bharat Petrol, Bharat Petrol,
Bharat Petroleum.
Bharat Petroleum.
In the respect of 23 acres and 16 cents of the property land situated in the town of the Bhavani for a period of 20 years on a quarterly rent of the rupees 300 for the purpose of erecting an installation and in one or more pumps, service and filling station together with the overhead or underground tanks and other fittings for the storage of the petrol products and such other facilities and building, and the lessee may be required for the carrying the business such a products through such a facility and other kindred motor accessories or any other trade or business that can be conveniently be carried or in the demised premises, the original lessor allegedly executed a will bequeathing the said site to her grandson. Of course, he is a Meenakshi Sundaram, who expired on the 3/11/1971, where the rent used to be paid to the guardian and mother of the said Meenakshi Sundaram SMT Chellamal. Of course, there is a release agreement would be there. Later on, the property is transferred to somebody else. Then, if that person is died over there, then who are the legal heirs for that one? They are entitled to get it, the property. Here, the appellant herein claimed itself the tenant in respect of the said premises, relying on basis of the provision of the Act. It was not disputed that the lessor, by the notice of dated 4/2/1987, purported to terminate the tenancy, calling upon the appellant herein to quit and deliver the peaceful and vacate the permission to the terms of the lease date. If the lease period is over, at that instance, the lessor wants him to vacate it. In reply, the said notice in the appellant here in terms of the letter so-and-so addressed to its advocate invoked the provision of the section 5273 of the Act, stating that had no intention to vacate the site of the property of the existing lease 336/1987, wished to continue occupying the same for a period of 20 years from 1/7/1987 by paying the existing rental of 500 per quarter by reason of the letter dated so-and-so. The appellant hereinafter exercised the option to renew the lease for the period of the 20 years commencing from the 1981. The same terms and conditions on such a Burma Shell had the lease immediately prior to the appointment day. Suppose if the lease period would be there, it is the discretion of the lessor to continue it or to make the lease continue renewed or not. Am I right?
Yes, sir.
At the time, you cannot make it out because the lease period is a very important factor. Suppose if the lease period is 20 years, can the lessor may ask him to vacate? Answer is
After 20 years, then
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे अहरह तव आह्वान प्रचारित सुनितव उदार वाणी